Hello there, and welcome to another Tidewater Viewpoint. This evening on our program, we're doing something that may be a little unusual because we are guests, non-paying guests, I might add, in Norfolk City Traffic Court. For our program this evening, Judge Vernon Hitchings, who presides over this court daily, is going to repeat for your benefit the instructions about the law which he gives to offenders who gather before him in traffic court each day here in the city of Norfolk. And we might add that these instructions would be beneficial to all of you, whether you live in Norfolk or not, because generally these are laws that apply throughout the state of Virginia at least, if not throughout the nation. So it's our very great pleasure by means of film to present to you now from his bench in Norfolk City Traffic Court, Judge Vernon Hitchings.
Good evening, ladies and gentlemen. The talk I'm going to make to you this evening is the same speech that we give every morning in traffic court before the docket begins, so that you'll understand what these new laws do in connection with taking your driver's license away from you. The reason for the announcement in traffic court is twofold. One, although ignorance of the law is no excuse for somebody that disobeys it, nevertheless, it's not very often the average person gets the law explained to him that he's supposed to know. Secondly, in our economy today, there's an increasing class of motorists that have to have a driver's license in connection with earning their living, so much so that it is as much a necessary part of earning their living as it is for a carpenter to have tools to ply his trade. In the past 2 years, the traffic laws in Virginia and Norfolk have changed radically from what they had ever been in the past 25 years or since the motor car became a problem in urban areas. Today, the punishment on a motorist for speeding or reckless driving is no longer confined to his pocketbook in the way of a fine, but now is, for the first time, being hooked to his right to drive a car. The reason being that a fine never accomplished a great deal in the way of deterring any motorist for several reasons. One, if he could afford the car, he could afford the fine, or he would at least raise the money and pay it in order to keep driving the car. Secondly, if the car were operated for business purposes, the cost of paying the fine was a business expense just like buying gas or oil for the automobile. Today, if you simply drive your car down to work and park it, get in it and go home, or the housewife who uses a family car for shopping, if your driver's license is taken away, the worst thing that will happen to you is to be inconvenienced. You'll have to ride the bus or have someone drive you. On the other hand, if you're in the category of motorist with this trend to the suburbs, such as a truck driver or a cab driver, a salesman with a route to cover, television repairman, and so forth, where your license is necessary for you to drive in order to earn your living, if your license is taken away, the chances are you're going to lose your job along with it. The reason being that the company cannot carry you on the payroll for 60 days, much less a year, if you cannot do what you're hired to do. Now, briefly, the legal situation boils down to this. If you get 2 convictions of speeding within a year, the State Division of Motor Vehicles will suspend your license for 60 days. They can take it for up to 6 months if it's 3rd or 4th offense. Twice within the year means that the second offense comes within 12 consecutive months of the first, with the result that if you had a speeding ticket, let's say in June of 1954, and you get another one between that time and June of 1955, that is twice within a year. It does not mean that both offenses have to occur in the same calendar year, say 1955. Secondly, if you get 2 convictions of reckless driving within a year, the state will take your license for 1 year. The court can take it for up to 6 months on first offense, but suppose, for example, you merely got a $25 fine on first offense reckless driving, and on second offense got the minimum $50 fine. Nevertheless, upon the report of those 2 convictions, the State Division of Motor Vehicles will suspend your license for 1 year. If you're convicted of drunken driving, which is driving under the influence of alcoholic beverages or drugs that are self-administered, your license will automatically be forfeited immediately by virtue of the conviction, and there's no time limit for practical purposes, on second offense drunken driving. With speeding or reckless driving, the second offense has to come within 12 months. But with drunken driving, it can come 10 years later, and on second offense would take the permit from 3 to 5 years. Now, in last July of 1954, the state legislature brought into being 2 additional laws which tightened the screw on the motorist to the extent that if you drive a car in excess of 75 miles an hour, no matter how straight down the road you may think it's going, no drinking involved, no accident or collision, nothing but speed alone in excess of 75 miles an hour is now deemed reckless driving by law, and the court must take your license for a minimum of 60 days. The other act, which was even more effective, ran this way. Up until that time, you had to get 2 convictions of the same kind. You got 2 tickets for speeding, you lost the license for 60 days. You got 2 convictions of reckless driving, you lost it for a year. Today, under the new law, if you get 1 of each within the 12-month period, it will act just like 2 tickets for speeding, and you lose your license for 2 months or 60 days. Consequently, if you have a speeding ticket or get one, and within a year get one for reckless driving or vice versa, you'll lose your permit under the same conditions as if you had achieved 2 tickets for speeding. Now, these convictions that I've mentioned are applicable anywhere in the state of Virginia. Frequently, people come here with a prior ticket in Richmond or out in the county somewhere, which counts against their record just as if it occurred in Norfolk. Furthermore, you are vulnerable to receiving a conviction for speeding or reckless driving in any of the surrounding states that border on Virginia, since we have reciprocity with all of them, and that would include North and South Carolina, Maryland, Pennsylvania, West Virginia, and Delaware. If you have a speeding ticket, say, in North Carolina, and within a year get one in Virginia, and now live in Norfolk, your license will be suspended just as if both offenses occurred over here on Granby Street in Norfolk. Now, that being the case, with the tightening of these new laws, it behooves all of us as motorists to pay attention to what you're doing in an automobile. For years, there has been an effort to preach traffic safety to people along this line. Drive carefully. The life you save may be your own. In my opinion, not many people have paid a great deal of attention to that theory for this reason. It's human nature to think of the pleasant things in life. Everyone thinks he's a good driver. Everyone thinks the accidents happen to someone else. For the first time in traffic law enforcement, we are beginning to cut down traffic deaths by working on the problem in a different manner. Today, you and I as motorists are faced with this basic a proposition. Either you drive the car correctly, which means within the speed limits wherever you are, and within the rules of the road so as to not be reckless, or else if you do not, you are then bound to accumulate 2 of these offenses, and upon doing so, you will not be allowed to drive the car at all. So today, the proposition has become this simple. If you're going to drive the car, you've got to drive it the right way, or you're not going to be allowed to drive it in any way. Today, your privilege to drive a car is not a constitutional right. It is merely a privilege issued by the state, and consequently, under certain conditions, it can be taken away if you become a violator. Now, last summer, you could see, and many of you did, when they put radar out here on the Virginia Beach Highway, how people slowed down. Today, every motorist knows that if he gets 2 of these offenses, he'll lose his driver's license. The result is, therefore, that people are slowing down in their driving. And when they slow down, they have fewer violations, they have fewer people killed, they have fewer people that have to come to traffic court. It's become that simple, and the only thing wrong with the theory is that it's about 20 years too late. I'm aware of the fact that nobody intends to do anything wrong with an automobile. No one gets in the car and says, let's see how many people that I can run over between here and the office. But the important thing for you to remember as a motorist is it's not what you intended to do. Very often it's what happened, whether accidentally or not, that you are held chargeable with. As a motorist, you're coming to face the proposition that you are almost deemed to have had a constructive intent of accepting the responsibilities of what you did. If you kill a man it makes no difference to him whether you shot him with a gun or ran over him while being careless with an automobile. The funeral service is the same. And consequently, it's too late for tears after an accident has occurred to wonder what might have been different. You've heard the expression, having a foot in the grave. I'd suggest to you that the next time you get in your automobile and start it up, that you look down on the floor and look at the foot that you have on the accelerator pedal, and you'll then know the foot that I'm talking about. There is no place that any of us have to go that is worth the risk of excess speed, with one or two exceptions. Consequently, when you drive a car today, you've got to devote your utmost attention to it, not just to save your own life, not just to be a careful driver, but to preserve your right to drive a car in the future. Therefore, when you leave today, as we tell people in traffic court, now is the time to reappraise your driving habits and see that you don't come here or any other traffic court anywhere. And remember that there is a primary duty of the motorist to avoid striking or running down a pedestrian. On the other hand, the pedestrian cannot depend on the motorist to always save him and must attend to his own safety in crossing streets. There is no reason in traffic safety, despite the good record that Norfolk has achieved, that if everyone tries, that Norfolk cannot become the safest city in the way of traffic hazards, accidents, and pedestrian safety of any city in the country.
That's about all.
Thank you very much, Judge Hitchings. It is true that we can very easily become the safest city in the country, because right now, with the present record that we have, I understand that we are the safest city in the country in our population classification. So we're going well. Let's keep it up. Thank you very much, Judge Vernon Hitchings, for permitting us to come into your Norfolk City Traffic Court to do this little film recording of the instructions and the information which you give to the offenders which gather before you in traffic court each morning. We trust that this information that Judge Hitchings has given will be helpful to you, and that it will keep you out of court in the future. Thanks very much for joining us for our regular session, this Tidewater Viewpoint. We invite you to be with us again tomorrow evening at this same time. So long until then.